Good morning. Uh, Yet another judgment which will help you, even if you are practicing exclusive criminal side and family court side, avoiding civil cases, because people may rush you to consult you whether any property which was mortgaged by him could be redeemed or not. That for that purpose you should understand what all are the nature of mortgage. Mortgage is one of the transfer method of property. Transfer method of property. There is so many categories of mortgage, uh, kinds of mortgages. But here the judgment which I am going to share with you would help you. If the mortgage is usurpatory mortgage, usurpatory mortgage means allowing the property be enjoyed by the person who pays money and the entire put till the money was repaid. So here is the case, the plaintiff, predecessors and some plaintiffs, there are 1 to 4 plaintiffs, seems to have filed, seems to have mortgaged the property in the year 1805 or something else, some very old, and so many 97 canals, 19 marlas. So that time to time, by Jamabandi, the lands were remarked and resurvey number, whatever the procedure during that period which was existing. Therefore, this was a fantastic judgment to understand the entire process. But the suit filed by the plaintiff was allowed by directing the plaintiff to pay the amount, accrued principal as well as the interest, and to get return of the possession of the property, and so on as contemplated under Order 34. So the question, the defendant, there were pro forma defendants. So what is meant by pro forma defendant means some defendant who may not be a party, but the other defendant may be coming with the aid of the pro forma defendant. That's what I understand the case. So the Punjab and Haryana High Court, AR 2025, Punjab and Haryana 36, Sham and others versus Shamavati and others. In this case, AR 2014 Supreme Court 3447, AR 2014 Supreme Court 2337 were followed. The judgment categorically discussed about what all are the mortgage: simple mortgage, mortgage by conditional sale, usurpatory mortgage, mortgage by deposit of title deeds, and anomalous mortgage, English mortgage. All these categories of mortgages are there. But the limitation set out in the Limitation Act for redeem or recover possession of immovable property mortgaged, it was stated 30 years. But here in the given case, the property was mortgaged in the year 1805 something, and suit seems to have been filed very late 2015. The suit was decreed and the appeal was also dismissed. So the question of limitation and the claiming of adverse possession was denied, and therefore the Punjab Haryana High Court held, by following Supreme Court judgment, that the period of limitation would not run for usurpatory mortgage specifically. So that was discussed at paragraph 62 of the Transfer of Property Act, at paragraph 14. Paragraph 14 was clearly discussed about various aspects, and finally they have given judgment and allowed the right to usurpatory mortgage under section 62 of the transfer of property commences in the manner specified therein when mortgage money is paid out of rents and profits of partly and partly payment or deposit by mortgage. Until then, limitation does not start for the purpose of Article 61 of the Schedule 2 Limitation Act. The usurpatory mortgage is not entitled to file suit for declaration that he became absolute owner on expiry of 30 years. The another principle was that once mortgage is always mortgage. So keep this on file. It will help you. Best wishes.